This is Tom Doody, middle-aged American living in New Jersey near the Lincoln Tunnel. If you were to visit my website, you would type Howdy Doody into Google. You'll find the correct spelling of the famous puppet. You then combine Tom Doody in a Google search from my site. In the Caribbean, there were shell companies named like Paradise Liquidity. This is a continuation of a New York Times article published November 2016 involving a wealthy couple divorcing, Sarah and Robert. The title is How to Hide $400 Million. In the Caribbean, there were shell companies with names like Paradise Liquidity and Integrity Investment Holdings, formed by Nevis holding companies and immediately transferred to Robert Cook Island Trust. There were a second Cook Island Trust that created in June. Wright, the Florida attorney, began nosing around Robert's business again. There was $35 million more in cash and bank accounts among their places in Monaco, Luxembourg, Canada, and the Bahamas. Yet on paper, it was hard to find anything that Robert actually owned himself. Shortly after Judge Gillen froze his assets, Robert removed himself as a beneficiary of the two trusts, even though they now appeared to contain much of the family's business property. The Toronto penthouse was owned by a Delaware corporation, which was owned by Nevis Corporation, deposited in one of the Cook's trusts. At some point, Omega had been transferred to one of the trusts. The Déjà Vu, meanwhile, was now owned by Caymans Corporation, whose membership interest, its partnership, had been shifted into one of its trusts. In exchange for trust, Robert paid the sum of $100. Unknown to his wife, Robert had even purchased an apartment complex in Georgia worth $23 million in loans backed by Housing and Urban Development. The application, which Potter obtained with the open records request, was personally signed by Robert, who listed an address in Boca Raton where they hadn't actually lived in at least 4 years. But after the sale closed in 2013, other documents indicated control of the apartment complex was shifted to a Bahamian company and finally to a trust. The United States government appeared to be guaranteeing $23 million loan to Cook Island Trust in the South Pacific. Robert's legal strategy was also becoming clear. Don't explain anything. The trust had hired a small Miami law firm called Kaplan Zena, whose lawyers excelled in navigating the complexity and opacity of the offshore legal world. They cited obscure international treaties and arcane points of Caribbean law. Potter told me they filed endless procedural and jurisdiction objections, burying Potter and Fisher in paperwork. Sarah was now receiving alimony and child support, but much of it was taken up by paying a jumbo mortgage and back taxes. Fisher would get paid from his firm work if she won. Kaplan Zenon, too, did not respond to emails seeking comment. Potter, who had to write most of the replying briefs, believed that Robert's trust were filing motions or objections. It seemed certain to lose just to exhaust and bankrupt Sarah. In one lawsuit, the trust fought against releasing a single piece of paper. A goal was merely to win. Potter felt, but to prevent the case from progressing far enough for its actual merit to be heard, this isn't some weird aspect of process, he says. This is a game itself. Nor could Fisher, despite invoking the authority of the Florida attorney against Robert, count on help from the Florida Attorney General. The office had sent a lawyer to monitor at least one hearing in Sarah's lawsuit, but had taken no official position on the claim. Fisher was on his own. But late in the fall of 2014, Robert ran short of a commodity that once seemed bona fide supply: time. For many months, his lawyers had successfully delayed Fisher's demands to depose him in person, insisting a variety of jurisdictional, geographic, practical complications. In the process, however, Robert had exhausted a patience of series of federal judges. Now, under threat of being held in contempt and potentially the courts issuing a warrant for his arrest, Robert agreed to show up in the Toronto law office. A video for the day shows arriving a few minutes late. "You're shorter than I thought you were," Robert told Fisher, but the rest of the deposition, Robert was dutifully restrained. He answered most of the questions in a monotone, rarely meeting Fisher's eyes. Fisher tried repeatedly to get Robert to list his assets. "I own lots of assets, different assets, various assets," Robert said vaguely. He had things that most people would have, like a watch. Was he really worth 768,834? Was he really worth 401 million, as his accountants once thought? Robert waved the question away. "I don't know where these numbers came from," he said, staring fixed at the table. "How did the penthouse end up in the Cook Island Trust? It was a transaction between me and my attorney." "Which attorney?" "I can't remember. I have too many." But bit by bit, Fisher began to connect Robert back to his own wealth. Robert admitted that he had signed a rental agreement to live in Toronto, penthouse, now owned by the trust. In that case, Fisher asked Robert who was paying rent. Robert looked up at the ceiling. "It's being accrued," he said. No money was actually changing hands. Under orders from Rosen, one of his lawyers, Robert, refused to say who was paying the utilities and maintenance of the penthouse. He admitted that the trust was paying to fuel and maintain Déjà Vu, a boat that was only personal permitted to. He was the only person permitted to use, according to a company's boat insurance contract. Documents accompanying the deposition provided further evidence that there was little distance between Robert and his theoretically independent trust holding his former property. The trusts were paying to furnish Robert with a private helicopter and even fund his trips to Saint Martin. In court papers that spring and summer, Fisher and Sarah, Toronto divorce lawyer Harold Neiman, sharpened their attacks. Robert was a highly successful internet swindler engaged in internet scams, forgeries, tax fraud, bank fraud, HUD fraud, immigration fraud, fraudulent overseas transfers, and other misconduct. Fisher told a Florida judge that they also moved to freeze even more of Robert's income, not just to make him suffer personally. Fisher and Potter estimated that Robert was bumping through about $1 million a month, much of it going to pay the lawyers and accountants keeping the maze of trusts and companies working order. In March, Fisher went after Wells Fargo, Robert's main link between name-brand financial services and the gray market of offshore shell companies and trust. The Wells Fargo accounts, they believed, were still accumulating revenue from some of Xacti's businesses, the ones selling travel deals, DVDs, and antivirus tools, some of which had been reconstituted under new offshore corporations. Fisher, citing Sarah's possibly forged signature removing her from the accounts, threatened to sue Wells Fargo, asserting that the bank had allowed Robert to defraud his wife of millions of dollars because of the competing claims on the accounts. Wells Fargo quickly froze them until the disputes could be settled. Now neither Robert nor the trust could access the money. As even bigger threat to Robert began taking shape, June 2015, a Florida judge ruled that Sarah was entitled to view thousands of pages of emails and documents exchanged by Robert and other executives at Xacti. This has been Tom, with the lawyers of Xacti, with their lawyers. It's been Tom Doody, middle-aged American living in New Jersey near the Lincoln Tunnel. If you were to visit my website, you would type Howdy Doody into Google. You'll find the correct spelling of the famous puppet. You then combine Tom Doody in a Google search from my site. Thank you for listening. Have a good day, good evening, a restful night's sleep. Ciao. End of part 7.